This case is a little bit tougher, okay? And this is actually a recent case from the States, believe it or not. We did come back over here. This is a case between an implement dealer and a farmer for the sale of a combine from the implement dealer to the farmer. After speaking with the implement dealer's sales representative about purchasing the combine, the farmer signed a purchase order and gave a check to the implement dealer, okay? They agreed to a price, well, they said this is the price, I think it was $52,800, okay? This is what the price is going to be. The farmer signed a purchase order and gave him a check, okay? Was there a contract?
If the sales rep can legally sign for the company.
Well, farmer signed the purchase order. That's what it says there. Farmer signed the purchase order and gave him a check, okay? Okay? Contract, everybody yes?
Yeah.
All right, does anybody say no? All right. More facts. The purchase order contained language that this order is subject to acceptance by the dealer. You said that. And it contained a signature line for the implement dealer to sign, which went unsigned by the implement dealer. Okay? Is there a contract?
No.
Okay, he gave him a check. He signed the purchase order, right?
The offeree never signed
Buyer
up.
and seller.
Okay. All right. So yeses, contract?
Was the check cash?
Huh?
Ah, good one, acceptance.
So yes, no contract?
No.
All right. More facts. According to the implement dealer, at the time the purchase order was signed and the check was delivered to the farmer told the implement dealer, I'll take the deal.
In those exact words?
I'll take the deal. That's exactly what he said. Is there a contract?
Well, it's a verbal contract, but clause 3, or whatever point 3 is kind of contradicts point 4, because it says that it has to be signed.
I'll take the deal. I'll take the deal.
No.
Here's a check, here's a purchase order, it's signed. I'll take the deal. Is it a contract?
But
So-
point 3 still says
Exactly
it
what I
has to
did.
be signed. So does that mean it negates the verbal contract?
It's new there.
I don't know. I'm not the lawyer here.
Does it matter when the dealer had to sign the acceptance? Because maybe the dealer was you're considering the dealer the owner, so you have a rep, sales rep, and then the owner has to authorize the rep's agreement with the farmer, right?
The purchase order is still unsigned by the dealer.
It's still unsigned?
Yep. But the farmer said, I'll take the deal, gave him a check, signed the purchase order. Okay. And if you say no, there's no deal. I want to know why.
Because Monty Python said so.
I like that.
Because the rep of the company didn't have the authority to set a sale price.
That's false.
Okay. That's a good answer.
I have a question. Why would there not be a contract? Is there a dispute somewhere? Does the farmer not want it afterwards?
Well, we'll
Does
just,
this-
hang on.
Well, I would say.
There is definitely a dispute, it was a case.
I would say there's no contract because it wasn't authorized by the dealer.
Did he cash the check? The dealer.
I don't think a check was ever cashed. But let's say the check was cashed. Let's say our purposes, the check was cashed.
Then that shows
It still wasn't signed.
Check was signed. The check was signed.
No, but the agreement, the purchase order wasn't signed by the dealer.
Okay, all right. The final fact is the farmer decided not to purchase combine because he thought it was too expensive. So maybe that answers your question. And of course, the implement dealer brought a lawsuit because we love attorneys and we love to pay our attorneys lots of money, right? All right. So what did the court decide? I'm hearing you guys kind of talk about a couple different things. Well, there's a couple different things here, okay? The trial court, okay, the court that originally heard this case found that there was a contract. All right? Court of Appeals, okay, because then what happens is you appeal it in the Court of Appeals because they want to spend more money on attorneys. Court of Appeals said, wait a second here. The offeror is the master of his offer. An offeror may prescribe as many conditions or terms of the method of acceptance as he may wish, including but not limited to the time, place, and manner. Okay? So, question in here, who is the offeror in this case? This is kind of important to this case. This is kind of a wonderful law school question, but who is the offeror and why?
So you would assume that the dealer was the offeror.
Why?
Except the buyer initiated.
Well, the buyer initiated by going to there and saying, I want to buy a combine,
Right,
right?
right.
The dealer prepared the purchase order.
It's whether you're looking at the combine as being the subject or the money to create the offer or designation.
Is the combine already for sale?
Yep. Yep.
So I would say the dealer is after or.
Okay. Okay, and why?
But the dealer doesn't really own the combine because he got it from the manufacturer.
Well, the dealer, for our purpose, let's say the dealer owns the combine.
Okay.
Sorry. I get to make up my own facts as we go.
Well, because by after or by putting it up for sale, he initiated the whole process.
Okay, okay, that's a good answer.
I mean, as a basic business practice, they're offering to sell things. I mean, that's what they're doing, a dealership is, right?
Yeah. Okay. Any other comments? Look like you're gonna say something back there. It's profound too.
I know. I would say the dealer is the offerer because he is offering to the public and the public responded.
Anybody say the farmer is the offerer?
My guess in this case, maybe that is the case, that the farmer is making an offer for something that they have
At a certain price.
at a certain price.
Based on what though?
The contract.
What do you may base that on? What's that? What'd you say, Mickey?
The contract that the farmer signed.
Okay.
Well, but you can't make an offer to give someone money unless there's something to give it for in the first place, right? I don't
Well, I'll
know.
take the money.
Yeah.
And in what instance does the buyer ever determine the conditions and terms
I
of
could
what they're
buy you a
buying?
pretty ring.
Well, you negotiate with for a car dealer or something like that, or a house, or, you
Well,
know,
that's, I mean, that's an interesting question, Dan, you do driveways, right? So who's the offeror? You do driveways, but if I come to you and say, I'd like my driveway done,
I would say I'm offering the service.
right?
He's offering his driveway for you to provide the service too.
It's kind of, sounds like,
We
it's
can't
like a pretty
operate
gray
without each
area.
other, so I guess, I don't know, it's hard, you know.
Who was the most expensive attorney?
I don't know that either, I'm sorry. I think this case was before my time too, based on the value of the combine, so. We'll answer it here. So let's take it up. The court concluded that the purchase order unambiguously required the signature of the implement deeder in order to be a proper acceptance of the farmer's offer. The farmer is the offeror, okay? Because the farmer signed the purchase order and made that offer to the dealer. The dealer, in order to accept it, had to sign off on the purchase order, and the dealer never did that. Now, where this case is really relevant, and there's a couple other paragraphs we got to go through here, but where this case is really relevant is how many, Dan, some of the contractors here, and some of the other people, like maybe you guys may even have it. How many times do you guys have a contract that says that, because you have other people that work for you, that this is subject to approval of the management or subject to approval of a certain person, okay? And how many times does that contract go unsigned by your company? And I see that a lot. I mean, that's one of the things that I actually see a lot. This is kind of an interesting case from that perspective because, and I've prepared contracts for clients that said, I specifically want to be able to control, because Dan, like you have people running around, selling driveways, right? And I guess I haven't seen your contract, so I don't know exactly what your contract says on this.
There's an acceptance signature on
By you,
Yeah.
right?
Authorization, it says.
Yep. So your sales rep can't bind you, you have to bind yourself.
Yep.
Okay? And in that case, if the sales rep comes back and the person calls up and says, Dan, I don't want to do this before you sign the contract, then the offer is terminated because the offeror is actually the customer in that case. Okay?
So couldn't that dealer have just signed it at any time though, or would the,
Oh, absolutely. He just didn't do it.
He didn't know he had to sign it.
Because
And I think if he would have signed it, in this case, it would have been a different case. It would have been an extremely different case.
I mean, I don't have, economy's not.
The farmer didn't want to buy it, was that the deal?
Yeah. Farmer changed his mind.
He thought it was too expensive.
Yep.
What
Farmer
happened
decided-
is the farmer went home and told his wife he bought the combine.
Actually, what happened was the farmer went to the implement dealer down the road, found
Found
it.
a cheaper one.
Well, the implement dealer down the road said, I'll sell the same combine to you for the same price, and the farmer said, you're too expensive. And the implement dealer said, well, if that's the case, I'm gonna sell it to you for less, okay? And the farmer said, hey, you're gonna sell it to me for less, great, I'm gonna do that. And then he went back to this guy and said, I don't want this anymore. So that's why we ended up in a lawsuit, so.
So if on mine, if my estimators bring back a contract that's signed by the customer and I authorize it, it's
Done deal.
it's a done deal. It doesn't matter if it was with the purchaser there or not.
Right.
then it's done.
Right.
But if it sits on your desk for 3 weeks and doesn't get signed,
That's a problem, potentially.
or if it sits on their desk and doesn't come to you,
Is there a problem though if the implement dealer did not receive, like say it was signed by the implement dealer, but he did not give a copy of the contract to the purchaser showing that it was signed? So the purchaser had no way of knowing. Does that play into it if the purchaser is not informed of the acceptance of the deal?
That's a really good question, and that wasn't in the fact pattern. I think that if they would have signed off on it, when it was delivered to the implement dealer, and they didn't deliver the contract back, I still think it would have been a binding contract.
But
I think.
how then do they prove if the purchaser or the farmer did not get a copy of the contract? The implement dealer could then say, well, they could have signed it the day that that's.
Right, and that comes back down to testimony. I mean, that would be some of the facts that would come out of court, and the judge would have to make a credibility determination that, hey, you look a little sleazy, I'm not gonna believe you today, that type of thing, okay?
So-
And I don't know how that would have played in if it wasn't delivered back. But I based on when I read this case, and based on what the trial court did, and based on how the Court of Appeals decided this case, I think that the farmer would have been stopped.
So, based on putting it in today's context, I would assume though that it's, if you want to make sure that your backside is covered, you want to make sure that you get a copy of the contract to the people that you're.
Absolutely.
and right away.
Absolutely.
And right away.
I would guess in this particular case, because this was a while ago, that contract went to court without ever being signed.
Right.
So that's how they knew it wasn't signed.
Yeah, that's exactly what happened. There's testimony that said it was never signed. That is absolutely true.
It seems excessively weird to me that the dealer would have brought suit against the farmer when he never signed
He
the
didn't know.
contract.
Well, he didn't. He figured they got a deal.
It's
The
all-
guy said,
He
"I'll
didn't
take the deal." He gave him a check. He signed the agreement.
Yeah.
And the fact of the matter is that if the farmer wasn't the offer or in this case, if they didn't decide that the farmer was the offer or, the offer or was the implement dealer, okay? When the farmer signed this agreement, then this would have been a binding contract. That's why that's so important. That's why this provision right here and what the court determined is so important, because that's what hinged this case on, was the fact that the farmer was the offeror and not the implement dealer.
And pretty much everybody in the room was in agreement that the implement dealer was the offeror.
Right.
And sometimes they don't even find out until they go and cash the check and the farmer voided it.
Yeah. Which could be other problems, but that's not
Right.
contract stuff. That's more issues. A couple things. What Sherry said too about contracts and you have to deliver them back. There are certain statutes out there, and there are certain industries that have a requirement that you have to give that contract back to the other side, in this case, the offeror. I think there's a contract or a statute out there for contractors that say that you have to give the person that you're working with a copy of the contract. Okay, so there are times and places where statutes actually override some of the ability for us as individuals or corporations to contract with people. Okay, that's something that you guys got to keep in mind, and we'll kind of go through that a little bit later. Okay.
So just off that, just real quick, like in a situation like with Dan, where if he's got a guy out at a house closing the sale, but Dan actually has to sign up on the contract. If the guy closes the sale, gives the customer the copy of the contract, and it doesn't have Dan's signature on it, is there potentially an issue there?
Yes. And I have to go back and look at that statute, because I think there's a statute out there, like I said. And Dan is a little bit different than normal contractors, I believe, based on what you guys do. But that's very statute,
It's not
very specific.
necessarily good enough for him to give the guy a copy of his contract, and then it comes back to Dan, and then Dan signs it.
And actually, I think the statute says a copy of signed contract. I don't know if his industry falls within that statute. One other note that you guys should know, and one other thing that came out of this case, that this is contract law across the land, but generally contracts are construed against the person who drafted it, okay? So if you're drafting the contract is going to be construed against you. So in this case, because the implement dealer drafted the contract, it's construed against them. So when they put that provision in there that said, hey, it has to be signed off by us, it was construed against them on that part, okay? All right. We sick of talking about combines?